Okay, let's unpack this. We are diving into a field that sits right at the intersection of, well, history, sociology, psychology, and some pretty hard data. We're talking about the foundational elements of criminology and criminal law.
Exactly. And if you've ever found yourself asking, why society chooses to punish certain behaviors, or maybe how the study of those behaviors actually became a rigorous science, then yeah, this deep dive is definitely for you.
That's our mission today. We aren't just going to read definitions out loud.
No, not at all. We want to give you a detailed framework, something solid, for understanding not just the concepts, but also the major disagreements, the technical complexities, and really the historical forces that shape how we define crime, how we measure it, and how we respond to it.
So we're going to define criminology properly, draw that crucial line between it and criminal justice. They're not the same thing.
A really important distinction, yeah.
We'll explore how society's definition of crime isn't fixed, it shifts. And we'll trace the history and the function of the legal codes that kind of underpin this whole field. So let's start right at the beginning with the science of criminal behavior itself. When we look at the core scientific definition, it's incredibly specific, isn't it?
It is. Criminology is explicitly the scientific approach to studying criminal behavior.
Right, scientific. So it's not just philosophy or someone's opinion.
Exactly. It demands applying rigorous, verifiable methods. Things like statistical analysis, surveys, observational studies, all geared towards understanding why people break rules.
But the complexity, I suppose, comes from the fact that the subject matter is human behavior, which is inherently unpredictable.
That's the challenge, and it's fascinating how broad that scientific scope has to be to try and capture the whole picture. Criminology focuses on 4 main processes, and they're all interlocked.
Okay.
The first, maybe the most immediate, is looking at crime as a social phenomenon. How does it actually show up in groups and communities? What do the national statistics tell us?
So looking at the observable facts first.
Right. Then it immediately pivots to the regulatory side, which is the second process, studying the making of laws.
So why does something become illegal in the first place?
Precisely. Criminologists look at that. What political group pushed for it? Was there some social pressure that drove that change?
Makes sense.
Following that, the third process is the actual breaking of laws and, crucially, the subsequent societal reaction toward the breaking the laws.
Okay, so that sounds like 2 sides of the same coin.
It really is. The breaking part involves etiology trying to figure out the cause of the crime. And the reaction part examines how society, through its institutions, responds, both to the offender and the offense itself.
And the whole point of this scientific exercise, as you mentioned, is that fourth point, the development of principles, building theories.
Yes. Criminology seeks to build systematic explanations, things that can help predict, help understand, and ultimately maybe influence policy regarding criminal acts.
And that focus on theory, on causality, that's the key difference, isn't it? Between criminology and the field it gets mixed up with all the time, criminal justice.
It absolutely is. Our sources really stress this. They are not interchangeable. They're related, deeply related, but majorly different fields.
I think this is probably the single most important clarification for anyone listening. Criminology is like the diagnostic lab, perhaps.
It's a good analogy.
Its role is to explain the origin of crime and the extent and nature of crime in society. It's asking the why questions.
Exactly. Why did this person commit this act? Or, why did the homicide rate suddenly spike last year?
If we connect this to the bigger picture, then, it really shows that one is about why crime happens, that's criminology, and the other is about what we actually do about it, that's criminal justice.
Precisely. Criminal justice is focused entirely on the mechanics of the response. It's the study of the agencies of social control. It deals with applied policy, procedure, the nuts and bolts.
And we can list those agencies specifically. That helps make it concrete for people. When we talk criminal justice, we mean the police enforcement, the court's adjudication, and corrections punishment, rehabilitation, all of that.
Exactly. So a criminal justice professional, they might be studying how effective a new court procedure is, or maybe the best way to staff a police patrol unit.
Practical application.
Whereas a criminologist is looking at why that suspect ended up in the patrol car to begin with. Or maybe whether the sentence the court handed down is actually based on a sound, evidence-based theory of deterrence.
So criminology provides the theoretical fuel.
And criminal justice provides the institutional engine. They work together.
It's an intellectual partnership, absolutely, but the roles are very distinct.
Very distinct. You need both, but you can't confuse them.
So if a criminologist develops a theory, say, that concentrated poverty leads to more property crime,
Right.
then the criminal justice system decides the operational steps. How many officers to deploy, maybe, or whether to try community-based sentencing programs to deal with the crime that results from that poverty.
Exactly. One informs the other, ideally.
Okay, so now we move from the science itself into the messy reality of what they actually study, the behavior. Because the law doesn't target all bad behavior, right? We have to talk about deviance first.
That's essential. Because the line between just, social behavior and criminal behavior is constantly shifting. It's not fixed. So deviant behavior, that's basically anything that departs from social norms, values, beliefs. But, and this is key, it's not always criminal.
Can you give an example?
Sure. Think about holding a really loud political rally that blocks traffic. It's definitely deviant. It departs from normal social expectations for using public space.
Okay, yeah. Annoying, maybe.
Right. But it might be a constitutionally protected non-criminal act. Deviant, but not criminal.
Got it. But then a crime. That's different. That's an act specifically deemed as socially harmful or dangerous.
And crucially, it's specifically defined, prohibited, and punished under the criminal law. The law is that essential, bright line. It separates what's merely unacceptable or weird from what's outright illegal.
And criminologists are really interested in this whole concept of deviance and how it relates to criminality.
Fundamentally.
Yeah.
Because it forces us to confront the question of societal choice. How does society decide? The crucial discussion point here, the one the field is always wrestling with, is how does society decide which acts to consider deviant and which acts to elevate to the status of criminalalis?
And I guess the simple answer is, it depends who you ask or which perspective you take.
That's exactly it. Because there are diverse views on this, defining crime universally is incredibly difficult. So criminologists tend to use three core perspectives to try and, nail down the societal mechanisms that actually generate these legal codes.
Okay, what are they?
The first is the consensus view. This one is maybe the easiest to grasp conceptually. It basically says that crimes are behaviors that are believed to be repugnant to all elements of society. They cause universal social harm.
So things everyone agrees on.
Pretty much. This view holds that the core criminal law, prohibitions against murder, rape, serious theft, arson, reflects shared values, morals, rules of conduct that the vast majority of citizens agree on.
Like a social contract idea. We all agree not to do these things because they're just inherently wrong.
Essentially, yes. And in this view, the law is seen as impartial. It's just the codified collective will of the people.
Okay, that's one view. What's next?
Then you have the conflict view. This one is far more critical, more historically aware, maybe. It depicts society not as harmonious, but as a collection of diverse groups in constant and continuing conflict. They're fighting over resources, over power, over ideology.
So not consensus at all.
Not at all.
Yeah.
And therefore, the law isn't seen as reflecting collective morality. It's seen as a weapon in that conflict.
A weapon used by?
Used by the powerful.
Yeah.
In the conflict view, law often reflects the interests of the social and political elite.
Okay, can you give an example of that?
Sure. A classic historical example is something like the Vagrancy Acts in early industrial England. These laws effectively criminalize being poor and unemployed.
Why would they do that?
Well, the conflict perspective would argue it was to ensure a large, available, and docile workforce for the new factories. The wealthy landowners and factory owners defined laws that protected their property and their economic system. They criminalized the survival strategies of the less powerful.
So the law itself becomes a tool of oppression in that view.
Exactly. If you compare two acts that cause similar societal harm, let's say a massive corporate environmental spill versus a person stealing $5 worth of food.
Right.
The conflict view argues the corporate entity is far less likely to be aggressively prosecuted or face the same level of consequences because the power structure protects its own. The definition of crime in this model is a mechanism of social control exerted by the powerful over the powerless.
That's a starkly different picture from the consensus view.
Very different. And then there's a third perspective, which is maybe the most nuanced, the interactionist view. Okay. This view holds that people, institutions, events, they're all viewed subjectively. They get labeled either good or evil, according to the interpretation of the evaluator. It focuses heavily on the process of social labeling.
So things aren't inherently criminal, they become criminal when we label them that way.
That's the core idea. This perspective stresses there's no real objective consensus on what's inherently criminal. Instead, you have what they call moral entrepreneurs.
Moral entrepreneurs.
Yeah, people or groups who campaign actively to have their values enacted into law. They succeed in labeling certain behaviors as deviant and then eventually as criminal.
And once a behavior is labeled criminal,
Then the enforcement apparatus, the police, the courts, steps in and solidifies that label through arrests and convictions. So the definition of crime, in this view, is really a product of social interaction and these moral campaigns.
that makes me think of things like the history of drug laws.
Absolutely. The historical criminalization of certain drugs, or conversely, the move towards legalization of cannabis today.
Yeah.
That's the interactionist view in action.
A behavior criminalized because of specific moral and political campaigning.
Is now being decriminalized or legalized because cultural labels are changing and new influential groups are pushing for that change.
Okay, so we have consensus, conflict, and interactionist views. They all seem to capture part of the picture.
They do. And to bring these disparate ideas together, the consensus on something like homicide, the conflict over economic regulations, the interactionist idea that labeling shapes reality a manifold, criminologists need an integrated definition, something that acknowledges the complexity.
So what is that resulting general definition?
It's a synthesis, really. It goes something like this. Crime is a violation of societal rules of behavior, as interpreted and expressed by a criminal legal code created by people holding social and political power.
Okay, that's dense. Let's break it down. Violation of societal rules of behavior.
That acknowledges the need for rules, the consensus part maybe.
As interpreted and expressed by a criminal legal code.
That brings in the formal legal aspect.
Created by people holding social and political power.
And there's the conflict and interactionist element right there. It immediately adds the crucial caveat. These rules aren't impartial or divinely ordained. They are written and enforced by people who hold the mechanisms of power in society.
It captures the tension.
Exactly. And the practical consequence of defining crime this way is pretty straightforward.
Which is?
Individuals who violate these rules are subject to sanctions by state authority. They face social stigma. They risk losing status. The state's power is the ultimate arbiter, ensuring compliance, regardless of whether that specific law originated from consensus, conflict, or labeling.
Okay, this is where it gets really interesting for me because we move from the theory, the what and why, to the actual application. What do people who study this stuff actually do all day?
Right. Well, criminologists, who are often trained in sociology, statistics, law, sometimes psychology, they tend to break their work down into several specialized subareas. Each one contributes a vital piece to the overall puzzle of understanding crime.
So it's not just one monolithic job.
Not at all. The first area, and maybe the most foundational for any kind of policymaking, is criminal statistics and crime measurement.
Okay, numbers.
Numbers, yeah. But it's the practical work of devising accurate methods for collecting crime data. And that is far more complex than just, counting up arrests.
Why is it so complex?
Well, their main task is measuring the amount and trends of criminal activity. But how do you measure something if it's not reported?
Ah, right. The hidden stuff.
Exactly. So criminologists have to grapple with two major sources of crime data, and they often tell different stories. You've got the official data, primarily the Uniform Crime Reports, or UCR, collected by the FBI. That's based on what police departments report.
Okay, crimes known to the police.
Crimes known to the police, and where an arrest is often made, depending on the specific UCR measure. But that only captures a fraction of what's really happening.
Because people don't always report crimes.
Precisely. Which is why criminologists also rely heavily on the National Crime Victimization Survey, or NCVS.
How does that work?
It's a huge survey. They contact households and ask people directly if they've been victims of crime, whether they reported it to the police or not.
Ah, so that gets at the unreported stuff.
It tries to, yes. Yeah. It helps expose that crucial issue of the dark figure of crime, all those crimes that happen, but never make it into the official police statistics.
That's a really key insight for anyone listening. The crime rate you see on the news, it's always just a partial picture.
Always. Criminologists spend a lot of time comparing UCR and NCVS data, looking for discrepancies, trying to understand reporting biases, and all that data analysis then helps them identify who commits crime demographic patterns and where those crimes are concentrated geographically.
And this work is essential for policy.
Absolutely essential. For measuring the effects of social policy, for instance. Did that new community policing initiative actually reduce crime, or did it just make people less likely to call the police? You need good measurement to know. It's also vital for measuring the effects of broader social trends on crime rates and for designing and evaluating crime prevention programs. Does this specific program work? The stats people help answer that.
Okay, so measurement is one big area. What else?
Moving on, you have socio-legal studies. This sub-area focuses intensely on the role social forces play in shaping the criminal law itself.
So less about counting crimes, more about the law's context.
Exactly. It's about the historical, philosophical, and social context of the law. They ask really challenging questions.
Like what?
Like, what's the actual history of legal thought? How did concepts like legal precedent even become solidified? How do major social forces think? Mass immigration, economic depressions, technological change. How do those forces shape the definition and the content of the law over time?
So, for example, how did the rise of, say, consumer culture create the need for complex fraud laws that just didn't exist 100 years ago?
That's a perfect example. They also study the impact of legal change on society. Does changing a law actually change behavior? And they look at that crucial relationship between law and social control. Is the law primarily about justice, or is it about maintaining order?
And this is where they'd study things like legalization or criminalization.
Yes, the effects of criminalizing certain drugs versus decriminalizing them. The shifting legal status of things like gambling or assisted suicide. It really emphasizes that the law isn't some static ancient document. It's a living thing, constantly being shaped by social pressures and power dynamics.
Okay. Then there's the core of the discipline, right? The theory part.
Right, theory construction and testing. A theory, in this scientific context, isn't just a guess. It's a systematic set of interrelated statements or principles that tries to explain some aspect of social life.
Explain why crime clusters in certain neighborhoods, for example.
Exactly. Or why certain individuals are more prone to offending than others. But these theories aren't just philosophical musings. They must be based on verifiable social facts on data.
And they have to be tested.
Rigorously. Using the scientific method. You construct hypotheses, specific, testable predictions derived from the theory, and then you assess those hypotheses using empirical research.
So if your theory is that better education reduces delinquency,
your hypothesis might be increased per pupil spending in schools will correlate with a decrease in juvenile arrest rates in that district. Then you need meticulous data collection and statistical modeling to see if the data actually supports that hypothesis and try to rule out other explanations.
it sounds like this research could focus on individuals or bigger societal structures.
It does. It often separates into micro-level theories, focusing on individual behavior, why does this person become a criminal? And macro-level theories, focusing on societal structures or rates. Why does this city have a higher crime rate than that one? These theorists are like the intellectual architects trying to build robust explanations for the foundational why.
Okay, what's the next sub-area?
Then we get more granular with criminal behavior systems and crime typologies. This involves researching specific types of crime and specific patterns of criminal behavior.
Because not all crime is the same.
Not at all. A serial bank robber operates very differently with different motivations and methods than a corporate embezzler or someone involved in street-level drug dealing. So this area looks specifically at violent crime, theft crime, public order crime like vandalism or prostitution, organized crime.
And typology means grouping them.
Yes. Research on the links among different types of crime and criminals is known as a crime typology. Instead of just studying crime in general, a researcher might specialize in, say, the motivational patterns behind serial homicide or the logistical structures of transnational drug trafficking rings. It provides a classification system, a way to make the overwhelming complexity of criminality more manageable for analysis and policy development.
Okay, that makes sense. You need categories.
You do. The fifth area, punishment, penology, and social control, represents probably the most direct overlap with criminal justice. But again, it's viewed through the lens of scientific efficacy.
So criminologists here are involved in creating effective crime policies.
Yes, and developing methods of social control, but methods that are hopefully grounded in evidence, not just tradition or gut feelings.
And the focus is on offenders.
Specifically, yes. The correction and control of known criminal offenders. This is where criminologists analyze whether specific rehabilitation programs like, say, cognitive behavioral therapy in prisons actually work better than just purely punitive sanctions like longer sentences.
Looking at what reduces reoffending.
Exactly. They study recidivism rates, the long-term effectiveness of different sentencing structures. They provide that essential feedback loop to the correctional system, asking, is what we're doing actually achieving its stated goals?
And finally,
Finally, a really crucial and frankly growing subarea is victimology.
focusing on the victims of crime.
Yes, the focus really shifted starting around the mid-20th century. Before that, criminology was almost entirely offender-focused. Victimology brought victims and the whole phenomenon of victimization into the scientific spotlight.
What kind of work do victimologists do?
It's broad, and it's deeply impactful. They work on measuring the nature and extent of criminal victimization, including trying to document the devastating frequency of crimes like domestic violence and sexual assault, which we know are often hugely underreported.
So more measurement, but from the victim side.
Yes, but also calculating the costs of victimization. And that includes not just the tangible financial losses, stolen property, medical bills, but also the immense intangible costs, psychological trauma, fear, reduced quality of life.
That sounds incredibly important.
It is. Victimologists also measure factors that increase the likelihood of someone becoming a victim. That's risk assessment. They study the victim's role, if any, in precipitating crime, which is a highly debated and ethically sensitive area, obviously.
Tread carefully there.
Absolutely. And crucially, their research is used to design and evaluate services for victims of crime, things like victim compensation funds, counseling services, support groups. It represents a significant shift in the focus of the justice system, moving towards trying to achieve some restorative balance and provide support, not just punish the offender.
It seems crystal clear that you can't really study criminal behavior without deeply understanding criminal law. They're intrinsically linked.
Absolutely. The law defines what behavior is criminal in the first place.
So to appreciate modern legal concepts, we probably need a quick look back, a bit of history to see where today's laws actually came from.
Definitely. We have to start where written law, or at least recorded written law, begins. The Code of Hammurabi. We're talking way back, around 2000 BC.
Hammurabi's Code.
Eh,
Famous.
Famous, yes. It was the first known comprehensive written criminal code, and its core principle was famously based on strict retribution, the concept of an eye for an eye, a tooth for a tooth.
Lex talionis.
Exactly. It sounds harsh to us now, but it set a huge historical precedent for punishment being proportionate and, importantly, official, administered by the state, not just personal or tribal blood feuds.
Okay, so state control and proportionality. What came next?
Moving forward quite a bit, the Mosaic Code, the laws attributed to Moses in the Old Testament, like the Ten Commandments, provided a foundation for Judeo-Christian moral teachings.
And that influenced the U.S. system.
Significantly, yes. Along with other ancient codes, it established principles that endure. Rules should be written down, they should be accessible, and violations should come with predetermined consequences. That idea of known fixed punishments.
But the system we have now, particularly in the U.S. and other English-speaking countries, comes more directly from England, right?
It does. The true direct ancestor is common law, which started emerging in early English law around the 1100s. It really solidified after the Norman conquest of England in 1066.
And common law wasn't written down by a king initially.
Not as a single code, no. It was essentially judge-made law. It developed organically based on precedents.
Meaning
Rulings in specific cases became the standard, commonly applied in all similar subsequent cases. This was formalized by the Latin principle stare decisis, which means to stand by things decided. The goal was consistency and predictability across the kingdom.
So judges looked back at previous similar cases to decide the current one?
Exactly. And within this developing common law, two really key concepts emerged that we still use today to categorize criminal acts.
Okay.
First, mala and savil. These are acts considered inherently evil and depraved. Crimes that are seen as wrong in and of themselves, regardless of whether a specific law or statute exists.
Like murder.
Murder, rape, serious theft. Acts that seem to violate some natural moral law they feel intrinsically wrong.
Okay, mala in se. What's the other one?
The other is mala prohibitum. These are acts that are considered wrong only because they are prohibited by parliament or a legislature. They're defined as wrong by law, but aren't necessarily seen as inherently immoral.
So things like traffic violations.
Traffic violations are the classic example, or highly specific tax evasion rules, maybe certain business regulations or zoning infractions. They're illegal because the law says so, to maintain order or achieve some regulatory goal.
And that distinction matters.
It's crucial. The severity of punishment, the level of social stigma attached, it often hinges on whether society views an act as mela in saya, truly evil, or merely malaprohibitum against the rules.
Okay, fast forward to today. How does law function in contemporary society? Are there different types?
Yes, we generally deal with 4 distinct types of law that structure how the whole legal apparatus functions. First, and most relevant to our discussion, is substantive criminal law.
That's the core.
That's the core. It defines what acts constitute a crime, and it specifies what the punishment should be for committing that crime. It outlines the substance of the law.
Okay, what else?
Then there's procedural criminal law. This governs the methods used to enforce the substantive law. It sets the rules of the game, basically.
Like rules for police investigations.
Exactly. Rules for search and seizure, Miranda rights. What constitutes admissible evidence in court? The right to a fair trial. It dictates the process by which guilt or innocence is determined.
So substance and procedure for criminal law. What are the other 2 types?
Beyond crime, you have civil law. This governs relationships between people or private entities. This is where you find things like torts, private wrongs, like negligence leading to injury contracts, property disputes, divorce. It's usually about resolving disputes and seeking compensation, not state punishment.
Okay. And the last one?
Public or administrative law. This deals with the relationship between citizens or organizations and government agencies. It sets rules for things like environmental protection, workplace safety, broadcasting regulations, the government regulating various activities.
Got it. So focusing back on criminal law today, how are crimes actually defined? Is it still common law?
Not primarily, no. Today, criminal behavior is defined mostly by statute. That means codified laws passed by Congress at the federal level or by state legislatures at the state level.
So written laws passed by lawmakers.
Correct. However, the common law tradition is still incredibly important because the content of those statutes is constantly shaped by judicial discretion. Judges interpret these often broadly written statutes when they apply them to specific cases.
So judges still play a big role in defining the law's meaning.
A huge role. And most importantly, towering over everything, every single federal and state law, whether statutory or interpreted by judges, must conform to the dictates of the U.S. Constitution, particularly the Bill of Rights.
The Constitution is the ultimate authority.
Absolutely. It sets the fundamental limits on what can be criminalized and how the law can be enforced.
Now, that substantive criminal law, the part defining crimes and punishments, you said it serves multiple functions. What are those?
Right. It does far more than just allow us to lock people up. Criminologists and legal scholars identify about 7 primary functions or purposes that substantive criminal law fulfills in society.
Okay, let's hear them.
First, maybe the most obvious, is enforcing social control, setting clear boundaries for behavior, telling people what they can and cannot do.
Makes sense. Order.
Second, and historically very important, is discouraging revenge. By providing a formal, state-sanctioned method for dealing with wrongdoing, it reduces the likelihood of individuals or groups engaging in private, retaliatory violence.
Replacing blood feuds with courts.
Essentially, yes. Third, the law acts as a kind of cultural mirror. It expresses public opinion and morality. It codifies, at least in theory, what society believes is right and wrong at a particular moment in time.
So it reflects values.
It reflects and reinforces values. Fourth, its punitive nature is intended to deter criminal behavior. This works on 2 levels. Specific deterrence.
Stopping the individual offender from doing it again.
Right. And general deterrence.
Showing everyone else what will happen if they break the law.
Exactly. Sending a message to the public. Fifth, it must fulfill that fundamental demand for justice by punishing wrongdoing. There's a deep societal need to see harmful acts met with consequences.
Retribution or just desserts.
Call it what you will, it's a core function. Sixth, it's essential for maintaining social order. By resolving disputes peacefully and defining expectations clearly, it helps society function smoothly.
And the last one, you said 7.
The 7th function, which is gaining more emphasis in modern thinking, is providing restoration. This aims to heal the harm caused by the crime.
How?
Often through things like victim restitution, making the offender pay back the victim, or community service, or restorative justice processes where offenders meet victims. It seeks to repair the damage, which is often in direct philosophical tension with the purely punitive functions like retribution.
Okay, so the law has all these goals, but how does it work in practice? How do you actually prove someone committed a crime in court?
Well, that gets us to the elements of criminal law. To get a conviction, the prosecution has to prove these elements, and the legal standard is incredibly high.
How high?
Guilt must be proven beyond a reasonable doubt in a court of law. This doesn't mean beyond all doubt, but it means that after hearing all the evidence, there should be no other logical explanation derived from the facts, except that the defendant committed the crime. It's the highest standard of proof in the legal system.
And what specific elements need to be proven to meet that standard?
Typically, for most serious crimes, they must prove two interconnected things occurred simultaneously. First, the actus reus.
Latin again. What does that mean?
It means the guilty act, the physical criminal act itself. Did the person actually perform a voluntary, prohibited action?
Like firing a gun or taking property.
Exactly. Or sometimes it can be an omission of failure to act when there's a legal duty to do so, like failing to pay taxes or a lifeguard failing to rescue someone.
Yeah.
But it has to be a voluntary act or omission.
Okay, the physical act. What's the second element?
The second equally important element is the mens rea.
More Latin.
Means the guilty mind. This is the criminal intent. Did the person intend to commit the crime? Did they have the required mental state?
So it's not enough just to do the act. You have to mean it.
Generally, yes. The legal system recognizes different levels of mens rea, different types of intent. It's often described as a hierarchy, maybe 4 main levels.
Okay.
At the top, you have purposefully the person consciously desired to commit the act and achieve the result. Then knowingly, they were practically certain their conduct would cause the result, even if they didn't necessarily desire it.
Lower levels.
Then recklessly, they consciously disregarded a substantial and unjustifiable risk that their conduct would cause harm. They knew there was a big risk, but did it anyway. And finally, negligently, they should have been aware of a substantial risk that a reasonable person would have recognized, but they weren't. They failed to perceive the risk.
So the required level of mens rea might vary depending on the crime.
Absolutely. For first-degree murder, you usually need purposeful intent. For manslaughter, recklessness might be enough. For some corporate crimes, maybe negligence suffices. The statute defining the crime will specify the required mental state.
So if someone punches a wall in frustration, that's the actus reus, the act.
Right.
But they accidentally hit a bystander they didn't see? Proving a purposeful mens rea for assaulting the bystander would be hard.
Very hard. But prosecutors might be able to prove reckless intent punching wildly near people, or maybe negligent intent, depending on the exact circumstances. You generally need both the prohibited act, actus reus, and the appropriate level of guilty mind, mens rea, occurring at the same time. That's called concurrence to secure a conviction for most serious crimes.
Are there exceptions? Crimes where you don't need mens rea?
Yes, there's a critical exception. Some crimes do not require mens rea at all. These are called strict liability crimes.
Strict liability.
It means proving the defendant committed the actus reus is enough for a conviction. Their mental state, their intent, or knowledge is irrelevant.
What kind of crimes are those?
They're usually less serious offenses, often regulatory in nature. Traffic violations are the classic example: speeding, running a red light. It doesn't matter if you intended to speed. If you did it, you're liable.
Any others?
In some jurisdictions, things like statutory rape, having sex with someone under the legal age of consent, can be strict liability, meaning the defendant's belief about the person's age might not be a defense. Certain environmental protection violations or selling alcohol to minors can also fall under strict liability. The idea is often to protect public health or safety by putting the burden entirely on the person engaging in the risky activity.
Okay, so even if the prosecution proves the actus reus and the mens rea, the defendant can still raise defenses.
Absolutely. A defendant can present criminal defenses. These generally fall into 3 broad philosophical categories.
What's the first?
The first is simply denial. The defendant argues the prosecution hasn't proven the elements beyond a reasonable doubt. They can deny the actus reus, it wasn't me, I have an alibi.
Or deny the mens rea.
Right. Yes, I took the car, actus reus, but I honestly believed it was mine because my friend said I could borrow it. That's asserting a mistake of fact that negates the necessary mens rea, the intent to steal.
Okay, denial. What's the second category?
The second category is excuses. Here, the defendant basically admits they committed the act, actus reus, but they claim they weren't criminally responsible because certain circumstances negate or diminish their blameworthiness, their capacity for rational choice, or their intent.
What kind of circumstances?
Our sources list 3 primary excuses. First, insanity. This is a legal concept, not just a medical one. Generally, it means that due to a mental disease or defect, the defendant either didn't know what they were doing or didn't know that it was wrong. Different legal tests exist, like the Imnaten rule.
Okay, insanity. What else?
Second, intoxication. Voluntary intoxication is usually not a full excuse, but involuntary intoxication, being drugged without your knowledge, might be. Also, sometimes severe intoxication, even if voluntary, might negate the ability to form the specific mens rea required for certain crimes, potentially reducing the charge.
And the third excuse?
Ignorance. Generally, ignorance of the law is not an excuse. You can't say, I didn't know murder was illegal. But ignorance or mistake of a key fact might be an excuse if it negates the required mens rea, like the car example earlier.
So, denial and excuses. What's the third category of defense?
The third category is justifications. Here, the defendant admits both the act, actus reus, and often the intent, mens rea, but claims the act was necessary or right under the circumstances to prevent a greater harm. The act itself was justified.
Okay, examples.
4 main justifications are usually discussed. First, necessity, committing a lesser crime to prevent a much larger catastrophe, like maybe breaking into an empty cabin to survive a blizzard, or speeding significantly to get someone having a heart attack to the hospital.
The lesser of two evils idea.
Exactly. Second, duress. This means the defendant was forced or coerced to commit the crime under an immediate threat of serious harm to themselves or others. They essentially had no reasonable alternative.
Like someone holding a gun to your head and forcing you to rob a bank.
That's the classic scenario, yes. Third, self-defense. Using reasonable force to protect oneself or sometimes others from an immediate perceived threat of unlawful harm. The force used must generally be proportionate to the threat.
A very common defense.
Very. And fourth, entrapment. This applies when the defendant claims the authorities, usually police or informants, induce them to commit a crime that they wouldn't have otherwise been predisposed to commit. It's about government overreach, essentially planting the idea for the crime.
So the police can't trick you into committing a crime you weren't planning on doing anyway.
That's the idea behind the entrapment defense. It's the constant negotiation between the prosecution proving the elements and the defense raising these denials, excuses, or justifications that really forms the backbone of the criminal trial process. It dictates how the criminal justice system applies the laws and, indirectly, the theories developed by criminologists.
Okay, so we've established the law as the foundation, but it's not set in stone, is it? You mentioned earlier it evolves.
Absolutely. The evolution of criminal law is a constant process. It has to be, really, to remain relevant. It's constantly changing, trying to reflect shifting social norms, economic conditions, technological advancements.
What drives that change?
It can be sudden, prompted by a highly publicized criminal case, some tragedy that exposes a gap in the existing law and creates public pressure for reform.
Right, a specific event can spur new legislation.
Definitely. Or change can be more gradual, resulting from slower shifts in culture and social conventions. Things that were once considered acceptable become unacceptable, or vice versa, forcing old laws to adapt to modern sensibilities and understandings. The law has to evolve, or it just becomes this archaic document disconnected from the society it's supposed to govern.
And it seems like the pace of change has really picked up recently.
It does seem that way. We can point to several specific examples of this evolution, showing the legal system reacting sometimes quickly, sometimes slowly, to modern societal issues. Often this reaction is prompted by those moral entrepreneurs we talked about, pushing for their view of right and wrong to be enshrined in law. The interactionist view in action.
Okay, what are some examples?
Well, think about the development of stalking laws, mostly in the 1990s and 2000s. These laws were a direct response to a growing cultural awareness of persistent, non-physical harassment patterns of behavior that caused immense fear, but didn't fit neatly into existing assault or trespassing laws.
So the law had to catch up to a newly recognized form of harm.
Exactly. Another incredibly complex area is the ongoing debate surrounding prohibiting assisted suicide. Here, the law is grappling with fundamental questions about life, death, autonomy, and the role of the medical profession. It's pushing the boundaries far beyond traditional definitions of homicide.
What else shows this evolution?
Other shifts include the creation of laws requiring registering sex offenders. The goal there is community safety and surveillance, but it raises complex issues about punishment duration and privacy. There's also the constant work of clarifying rape definitions in law. Making sure statutes are gender neutral, that they encompass various forms of non-consensual sexual acts beyond just forcible intercourse, reflecting a deeper and more victim-centered understanding of sexual violence.
And then there are things moving the other way towards less criminalization.
Absolutely. One of the most prominent and contentious examples is the trend towards legalizing marijuana in various states and countries. That's a massive reversal of nearly a century of prohibition, moving it away from being mala prohibitum.
A huge shift driven by changing social attitudes and economic arguments.
Definitely. And finally, think about the ongoing legal response to terrorism, particularly after 9/11. This has created an entirely new body of law dealing with surveillance, detention, definitions of enemy combatants, fundamentally altering the balance between security and civil liberties.
So all these examples really drive home the point. The legal code, the very definition of what constitutes a crime, is constantly in flux. It's being negotiated by social forces, political power, tragic events.
Which loops right back to that integrated definition of crime. We discuss a violation of rules expressed in a code created by people holding social and political power. That power dynamic is always present in the evolution of law.
And this dynamic legal environment must create challenges for the people studying crime scientifically, right? For criminologists.
Profound challenges. Because criminological research results don't exist in a vacuum. They carry significant political and social consequences.
So,
Research findings can be used to justify policies like mass incarceration, or conversely, to argue for defunding police units. They can influence sentencing guidelines, parole decisions, prevention program funding. So criminologists need a deep awareness of the ethical issues in criminological research.
what are the main ethical pressure points?
They're often framed around three major debates or questions that researchers constantly grapple with. These really determine how research gets done and what kinds of conclusions are drawn. The first is fundamental: what to study.
How is that an ethical issue? Don't researchers just study what interests them?
Sometimes. Scholarly interests play a role, of course. So do perceived social needs, studying a problem that's causing obvious harm. But the simple availability of data can also drive research agendas. And critically, so can funding.
The money.
The money. What's particularly notable in recent decades is the massive influence of governmental funding. Federal grants, for example, often direct criminological inquiry towards specific topics that align with current political priorities.
So if the government wants research on street gangs,
Then grants become available for studying street gangs. Criminologists who want funding will naturally gravitate towards that topic. This can potentially draw resources and attention away from studying other, perhaps equally harmful areas like corporate crime or political corruption that might receive less political attention or be harder to get funding for.
that creates a potential bias in what gets studied, driven by the funding source.
It's a significant ethical concern, yeah. The second major debate is whom to study.
Meaning the subjects of the research.
Exactly. Criminologists have an ethical obligation to actively fight the historical tendency, and it's a strong tendency to focus research primarily on poor, marginalized communities, while often ignoring criminality among the more powerful segments of society.
So if you only study drug offenses by looking at street-level dealers in inner cities,
You create a skewed picture. You develop theories based on that specific population, which might not apply elsewhere. It reinforces stereotypes and fails to capture the full spectrum of criminality across all social classes and types of crime. If the field only publishes research on street crime, the theories developed will be incomplete, potentially biased, and maybe even unjust. They ignore the criminality that might be embedded in white-collar professions or high-level political dealings.
so researchers need to strive for representative samples.
Unbiased, representative samples are crucial for ethical and scientifically valid research, which leads directly to the third major debate: how to study.
The methods themselves.
Yes, this involves both methodological integrity and the ethical treatment of human subjects. There's a fundamental requirement for unbiased and random selection of subjects whenever possible in study designs, ensuring the results are generalizable and not just reflecting the researcher's conscious or unconscious preferences.
And protecting the people involved.
That's paramount. The highest ethical standard requires researchers to protect the subjects chosen for their studies, whether they're in experimental groups or control groups. This means ensuring privacy, guaranteeing confidentiality wherever possible, obtaining informed consent, and prioritizing the well-being and safety of the individuals above the potential scientific knowledge or policy gain.
Especially important when dealing with vulnerable groups.
Absolutely. Yeah. Especially when studying people in vulnerable situations like prisoners, crime victims, juveniles, or those with mental health issues. The potential for harm is greater, so the ethical safeguards must be even stronger. Hashtag tag outro.
Wow, okay. So we've really covered a lot of ground here. A proper deep dive into the science of deviance, crime, and law. We've worked hard to clearly distinguish criminology, the science asking why crime happens, focusing on theory, causes, measurement.
Right, the diagnostic lab idea.
From criminal justice, which is the more operational study of how society responds through its agencies, police, courts, corrections.
A crucial distinction. We also navigated those three critical views of crime consensus, conflict, and interactionist. They really show us that the definition of crime isn't some fixed, objective list. It's a social document, constantly shifting, deeply reflecting power dynamics in society.
And we traced the legal structure back through history, from the harsh retribution of Hammurabi's Code to the foundational principles of common law. And we detailed those essential dual elements required to prove most crimes: the physical act, the actus reus, and the guilty mind, the mens rea.
Along with the defenses that challenge those elements.
So, wrapping this all up, what does it all mean? It seems the whole field exists in this state of, well, productive tension.
That's a good way to put it.
It's constantly balancing these ancient ideas of right and wrong, often rooted in concepts like mala and se, against today's complex and rapidly evolving social issues, everything from clarifying intent in sophisticated financial fraud cases to deciding whether or not to legalize drugs like marijuana.
Exactly. The study of crime, therefore, isn't just about criminals. It's fundamentally the study of how society chooses, moment by moment, to draw its moral and legal boundaries. And who gets to hold the pen while drawing those lines.
Which brings us to a final thought, maybe something for you, the listener, to mull over, building on everything we've discussed.
Given that integrated definition of crime we landed on, that it's a violation of rules expressed in a legal code created and interpreted by people holding social and political power.
Right.
How should criminologists, as scientists trying to be objective, ethically navigate the conflicts that inevitably arise? Especially when the very subjects they study, the populations they focus on, and often even the funding they receive to do their research, are determined by the very power structures and legal systems they are simultaneously trying to scientifically explain, critique, and potentially reform.
That's a profound tension, isn't it, between striving for objective science and operating within a system inherently shaped by political and social power.
It remains the defining challenge, I think, right at the heart of the discipline of criminology.